Welcome again. And we can see that we have 67 participants, and we're hoping that we will have more participants here today. And I will request everyone to write your name, designation, and organization in our chat box to introduce yourself to each other. And we're hoping to start now, and we're hoping that everybody will join by this time. And hello, everyone. Before you start, let me confirm that my microphone is working. And hello again to the webinar on examining the legal framework and its implication for CSOs handling SEAH complaints in Bangladesh from the Safeguarding Research and Support Hub. I'm Firdaus Nahid, National Representative, RSH Bangladesh. And we are going to do a learning session and know the knowledge on this topic today. The RSH is a program that aims to support organizations in the development and humanitarian sector to strengthen their safeguarding policy and practice against sexual exploitation, abuse, and sexual harassment. RSH supports all organizations working these sectors, but is driven by the needs of smaller national or local organizations. RCG are funded by UK Aid, the UK government's Foreign, Commonwealth and Development Office to help organizations around the world, and is a consortium led by Options with Social Development Direct as the technical and delivery lead, and including the International Council of Voluntary Agencies, Terra the Helms, Site Savers, and Clear Glover. Now, before we start, let us remind ourselves of a few points on housekeeping. First, you are all on mute with your videos turned off. This is to support the quality and connection of the event so that the internet connection remains very smooth for the webinar. If you have any questions or inquiries, please use the chat or Q&A feature. The panelist and team will respond accordingly. The event will be held in Bangla with English translation available. To choose the language of preference, please select the globe icon and choose the language of your preference. The selected language will be activated momentarily. Please don't miss the original channel. Please be aware that the event will be recorded and shared on the online hub afterwards for anyone who was not able to join, and your names will not be visible. The event duration is 1 hour, and by the end of the event, we'll ask you to fill the feedback form that will appear on your screens. And please remember, this feedback form is very important for us because we will know that how did you find this event impactful for your work, how did you like, and it will help us to make the future event better. And I would like to share the agendas for today's event. Today's webinar is to have an overview of existing legal framework of Bangladesh on SEAH. And today, we have panelists today. So we have Kamran Nasli is a lawyer by training and human rights practitioner by professional. Currently, she is working as an independent consultant and researcher. He will discuss different issues. And our second speaker is Advocate Dilip Kumar Paul is a human rights and lawyer with 29 years experience with the compliance experience, and he will share his learning. And in the last section in the webinar, we will have a Q&A session where you can ask questions to panelists. And finally, several questions will appear at the end of the webinar for you to provide us with the feedback on the event. Now, without further ado, let me now hand over to our first panelist, Kamrunessa Appa. Now, I will say a little bit about Nazli Appa. She is a lawyer by training and a human rights practitioner by profession. Currently, she is working as an independent consultant and researcher. She's also working with RSH. She's also a senior advisor here. She will discuss overview of the national legal framework, SEAH, in Bangladesh. Now, we have a second speaker here, who is Advocate Dilip Kumar Paul. if I talk about him, he's a human rights lawyer who carries more than 29 years of experience in dealing court cases, primarily with criminal cases and family matters. He'll share compliance with national laws in safeguarding complaints handling and potential gaps and constraints for CSOs. Without a delay, I will request Nazli Appa to share her presentation with us. So I'm welcoming Nazli Appa. Please come and share your presentation. Thank you, Ferdowsai. And I feel like Ferdowsai already talked about me, but my name is Nazli. I'm a lawyer. I am working as an independent consultant on gender equality and women's empowerment, and I'm also associated with SEAH. I will be discussing about relevant the national laws of SEAH issues in Bangladesh. Then I'll be briefly discuss about the scopes and content of the laws, which will be help us to understand the relevance of these laws on SEAH issues. Then very briefly, I will talk about the relevance of these laws on safeguarding against sexual exploitation, abuse, and harassment. Then I'll be discussing about the reporting on SEAH issues. After that, I will talk about the relevance and considering survivor-centered approach to do no harm. First of all, I want to talk about the Constitution of Bangladesh. Bangladesh does not have any specific law on prevention and protection of SEAH. However, there are numerous laws that address issues of SEAH safeguarding under the broader continuum of sexual and gender-based violence. Here, I will just sharing the name of laws. There are relevant on SEAH issues. There are a lot of act I can talk about: Constitution, Penal Code, acid crime, pornography, mobile code, cybersecurity, Labor Act 2006, and last, the guideline of the High Court Division on the issues of sexual harassment at workplace, educational institution or universities or any other places. This is the most last updated one. So mainly I'm going to discuss regarding all these issues in my later slides. Can we move to the next slide, please? First, the Constitution. Well, just now I was talking about the Constitution. First, the Constitution of Bangladesh. The Constitution prohibits discrimination between citizens, including sex-based discrimination, and guarantees equal rights of women and men in all spheres of state and public life. Now, the Constitution embodies principles of ensuring the attainment of a just and egalitarian society free from the exploitation, which is involved in Article 10, and ensuring equality of opportunity to all citizens, which is under Article 19. As fundamental principle of state, the Constitution also prohibits discrimination on ground only of religion, race, caste, sex, or place of birth as a fundamental right. And who we are working with the gender equality, we know how much we actually do practice. And we know that it happened in 2000, that is the Prevention of Repression Against Women and Child Act. Criminalized different sexual offenses against women and children, including rape, murder after rape, trafficking, sexual harassment, dowry, causing death for dowry. We know how much we do practice on these issues and on this act. So, and abduction, including punishment, provision of these such offenses, we really talk about it and we really do practice on this. Can we move to the next slide, please? Now we want to talk about that acid crime prevention. So I will definitely talk about that. It comes under a very strong act, criminalized offense to death and injury acid. Now the another strong act comes on Pornography Control Act 2012. Now criminalizing pornography and makes the possession, distribution, production, and using of pornography material. It all came under a punishment act. So High Court rules all this act under the punishment. So all these are very relevant with the SEAH Act. Now, the third act that I'm talking about, the Prevention and Suppression of Human Trafficking Act. So if you see the criminalize of all forms of human trafficking, forced labor, debt bondage, and kidnapping for the purpose of human trafficking, exploitation through prostitution, etc. If you see, all these acts are very relevant with the SEAH and safeguarding issues. And all these, they guidance and include specific provision for institutionalization of internal complaints procedure to address the issues of sexual harassment. So if we say in the same way, can you move to the next slide, please? And the second slide, there is a Cybersecurity Act um, addresses offensive, false, or intimidating transmission of information, or anybody is doing, threatening for publication, etc., and publication, dissemination, etc., of defamatory information. So anybody is doing harassment through this threatenation. So everybody comes under this act. So this act help us to address those issues and resolve those issues. We also have Mobile Court Act 2009, which empowers the executive magistrates to try the offenses under Section 509 related to sexual harassment of the Penal Code. So we know that all sexual harassment issues comes in immediate action state. Also, we can talk about Labor Act 2006 and Labor Rules 2015, amended in 2012. So in Section 332 of Labor Act and Rule 37 of the Labor Rules 2015 prohibits the derogatory behavior against women in general and pregnant women. So we know that how the Labor Act actually shows a protection or help us to take action as an organization to how to address those reporting or those issues. So we actually, these acts and rules actually helping us to formalize the complaints or formalize to address those complaints. Rule 361 of the Labor Rules 2022, which is definition of sexual harassment, constitution of complaints, committee and guideline of prevention of sexual harassment. So it says strictly or give us the instruction from the High Court that it's an instruction to the organization so that they actually produce the guideline to stop sexual harassment or to prevent sexual harassment, or what will be the action after the sexual harassment. If you go to the next slide, in this slide, I will share that about the High Court guideline on on the issue of sexual harassment at workplace, educational institution or universities, or other places, 2009. The High Court guidelines are the set of directives in the form of guidelines to be followed and observed at all workplaces and educational institutions until adequate and effective legislation is enacted in this field. It defines sexual harassment and provides for taking preventive and disciplinary actions for committing sexual harassment at workplaces and in educational institutions. The guideline includes specific provision for institutionalization of internal complaints procedure to address the issues of sexual harassment. So always the guideline includes specific direction, and it guides the organization how to define how they will actually address or how they will define the sexual harassment. So organization can actually design the mechanism to establish those system in the organization. So High Court actually provided a specific and directive guidelines. So we will go to the next slide now, please. Can we go to the next slide, please? Okay, in this slide, I'm going to share how this law, but I'm not going to going in too much of details because it's gonna take a lot of time. But I'm going to, because I know my next speaker is going to talk about it a lot, but I'm going to share how these laws are relevant on these safeguarding issues. I know Firdaus Bhai was saying in the beginning that um, how that it is going to has strong law. Uh, they have a strong law we have, and how it is relevant to improve. Yeah, overall CSOs has a relevance, but there are a lot of acts are there. But is there improved? We can see a lot of acts are there in the High Court guideline, but there are a lot of relevance also with the act. But the laws are mentioned above address issues of safeguarding under the broader continuum of sexual gender-based violence. These instruments provide a framework to get redress on complaint against sexual exploitation, abuse, and harassment, such as sexual harassment, online abuse, through formal justice system. Now, we see a lot of online harassment. Now, we have seen the online sexual exploitation. So we have seen those kind of things are coming under the act now. Can we go to the next slide, please? So there is no mandatory report. What we are saying that there no mandatory report for SEAH within development and humanitarian context in Bangladesh. Through all the laws as mentioned above provided for the reporting procedure to the formal justice system according to the laws, aggressive person or anything. So there is no mandatory reporting for SEAH within development humanitarian context, but everything has been mentioned, the act that I mentioned. So the guideline has been given, but the organization has the liberty. So they can design by them, but that is not bound. We are not bound to do that. But all the laws mentioned above only provide a reporting procedure to the formal justice system. All right. So it's not organization are not bound to do that. So that's where we can see lacking. We also see that however the High Court guidelines stipulates that the matter is referred to the appropriate court or tribunal if the act complained of constitutes an offense under any penal law. So it has been ensured that it will come under the punishment or justice. Okay, we can move to the next slide now. While reporting on the SEAH complaints, following aspects to be main consideration following the survivor-centered approach and do no harm principle. So that is very important. I would like to mention again and again that principles are very important. While we are doing the reporting, it can be a formal reporting or informal reporting. We will remain in the previous slide, please. So who are the survivor who we are calling survivor? So we have to see, do they have the consent on this reporting? We will move to the previous slide, please. So it is important to know whether they have their best interest, and also do we follow the policy of do no harm? What does it mean? Consideration of the risk for well-being and safety of the survivor. It is very important. So I can give two reference here that why it is so important. We get guidance to comply, survivor-centered approach, two references given here. Of provision of prohibiting disclosure of identify of rape victims, of the Prevention of Repression Against Women and Children Act, identify of the complaint. I'm finishing here, and thank you so much to everyone. And thank you, Nazliapa, and sharing all your learning with us. And we have learned from you on the legal view framework to CHI. And I would like to invite Dilipta for sharing his view on the compliance. And thank you, Ferdowsbhai, and for inviting me in this webinar. I am Dilip Hall. I'm the advocate practicing in Dhaka today. I will be discussing about the compliance issue for the CSOs. I will be discussing compliance issue for the CSOs in safeguarding complaints handling. I will mainly discuss 3 issues. How CSOs can ensure compliance with national laws in dealing with sexual exploitation, abuse, harassment issues, potential gaps and constraints for CSOs in ensuring compliance with national laws regarding SEAH complaints, and overcoming the gaps by the CSOs. So those will be my um, my discussing issues. And I know in my previous presentation, Nazli shared about the relevant laws on SEAH issues. I will discuss how CSOs can comply with these laws. What's the first step for ensuring compliance with the laws? So now I know Nazli has actually found all the equality and the gender issues. Now, here I am specifically to talk about the 3 topics. Now, I'm very interested to talk about how CSOs can ensure compliance. Mm, And I am very enthusiastic to talk about because of my long experience. Second thing is that the gap and constraints for CSOs. So what is the country act is available? And we know all the gap, like as you heard from that, we have broader line acts are there, but where is gaps and constraints? And another thing is that what we can do to address or overcome those gaps. So once we actually in the organization need to include clear reference as the first step to ensure compliance with the laws. The organization need to include clear reference on alignment with different laws, such as the High Court guidelines, the Prevention of Repression Against Women and Children Act 2000. Now, this is very important. Now, if the relevance and alignment is, if it is not there, I will definitely request that please align yourself with this act and bring those reference. And this is a high time where you can actually take these actions and in their organization. So where you can do this alignment in organizational policies and procedures. So you are actually aligning yourself with the country act or country constitution, I would say. And now this can be the first step. Now what can be the second step? As a second step, when a complaint is received on SEAH issues, organization need to screen, right? First, to screen each individual complaints if it constitutes criminal offense under any existing law of Bangladesh. Screen thoroughly, screen whichever way possible, such as sexual abuse, right? Is it coming in any existing law? Clear reference in the policy will guide the organization to ensure the screening. The organization also need to inform the victim survivors about the available remedy according to the screening findings. Thereafter, the organization need to have mechanism to assist um, survivor in accessing legal remedy, right? So this is the third a step, I would say. Now, who is the victim? Therefore, you have to inform them. It comes under a crime, right? So, and also we have to, as organization have to inform the survivor what are the acts available there. So, it is very important to organization to have the mechanism to assist the survivor in accessing legal remedy. I would say, NGO legal aid organization explaining to the survivor to the step that will be required after they are referred to local authorities. That are not legal obligation, but moral obligation. I would say, so they can actually help them. So internal procedure, there can be talking disciplinary actions against the preparatory. So if the complaint constitutes criminal offense like sexual abuse, inform them about the available legal remedy, right? So what is the remedy available, how they can receive the after action, and what are the steps after steps? And, communicate clearly. Okay, can you move to the next slide? Okay. Now, I will present the complaint and handling procedure. Now, first we have to do, according to the High Court guideline, what is the procedure? Constituting a complaint committee to receive complaint and to conduct investigation and make recommendation. We have to prepare a committee, right? Now, complaint committee, we have to prepare I would say we have to make a committee. If we don't have a committee, we have to create one. And every organization need a committee that actually takes the complaint or receives the complaint. Definitely, a lot of you know already that we need that, and High Court already ruled this guideline. We need a committee where we will have 5 members. Now, if it is possible, we will have the committee who will be head or led by a woman. And also, committee should have at least 2 members from outside. It's a 5-member committee and 2 members from outside of the organization, preferably from organization working on gender issues and sexual abuse. So complaint normally to be lodged. Now, can we go to the next slide, please? Okay. So now High Court is also saying ensuring that the identity of the complaint and also that of the folk accused are not disclosed until the allegation is proved. So it has to be ensured by the organization, right? So this is a very big responsibility, and confidentiality has to be maintained by the organization. Now, from my experience, while I'm working, I have seen a lot of cases. Once the survivor or the victim, they come for complaint, once they come for complaint, the perpetrator, they actually know that they are accused and they start abusing more to the survivor. This case cannot be happen. So organization has to be so confidential and so secure to this complaint. So this opportunity has to be ensured by the organization. Ensuring the security of complaint by the concerned authority. Also, there is a opportunity has to be a woman member that they can go securely how they want to go and do the complaint. And the complaint normally has to be a flexible way how they are doing the complaint. So organization can do the mechanism how the complaint can be collected. It can be formal complaint, it can be physical, it can be online, it can be through letter, it can be through email. It can be through a complaint box. So there can be a lot of example to collect those to collect um, complaints. And in the organization, all the member will be aware that there is an activity going on to collect this kind of complaint. So everybody will be aware and concerned, and they will be more aware of the act and action. There is more important thing in the High Court guideline, that is complaint normally to be lodged within the complaint committee within 30 working days of the occurrence. Complaint committee should submit investigation report with recommendation within 30 working days to be concerned authority. The period of 30 days may be extended up to 60 days where it is found necessary. Now, if it is a small act, it can be even shorter. But if it is a very small that they can actually decide and can like it can be solved, they can do it in very short period of time. But if it is not long, if it is not a short case, if it is a lengthy case, they actually need an investigation. They can take up to 60 days, but it has to be resolved in between that period of time. And they have to recommend all those investigation report in between that period of time. That means High Court expect the organization to act quickly on those reports. So that means from 30 days to 60 days, the total period of time to act on this complaint. We'll move to the next slide, please. Now, it will here will first share about the, we have talked about the compliance issues. We have talked in the previous slides. Now I'm going to talk about the gaps, right? Now organizations are working with these acts on the SEAH issues, harassment issues, and while they're taking care of the complaints, now they have found different gaps, right? Now I'm going to talk about those gaps here. If we talk about first, the first gap is the lack of any specific law on sexual harassment and abuse issues. We have a specific law. High Court has given us a rule, and they have given a very specific law, which is a good thing, obviously. And it happened in 2019, right? But unfortunately, now that time High Court has been saying that government will act on this, right? But even after 15 years, High Court guideline, we still don't have a law on the SEAH issue. Then there are ambiguity overlapping of the scopes and jurisdiction. For example, pornography is a criminal offense. However, according to the High Court guideline, pornography is to be dealt internally following the procedure provided by High Court guideline, right? So just an example. Now, we have actually tried to convey this message to court, to government. We are still trying, will be trying in future, but still it is a little bit under ambiguity that how and when this law will be coming. But still we are guided or recommended to act internally according to the High Court guideline. But fortunately in India and Sri Lanka, they already passed this law because they have bring it under the law and they can actually do the punishment under the law very quickly. So there are, for example, Labor Act non-government organization from the general application of labor law. According to Section 1(4) of the Labor Act, any establishment carried treatment, care, service, and sick, right? Disabled, distressed, disabled, orphan woman, and child or widow, but not for profit or profit are exempt from the scope of labor law. So there are different cases of like examples, as I mentioned in pornography, as I mentioned in labor law. So these are the examples I'm going to talk about that government involved and law enforcement team is environment. They are doing the investigation, but because of there is no existence of specific law, a lot of time investigation is not rapid, right? Investigation happens in slow moment. Same happens in labor law. So we are in the same confusion with the labor law. So once we actually investigate with the section 14D, which organization will be included? There is a confusion. Can we include this organization or not? Can we include these women under labor law or not? So they are kind of overlapping of information because of too many act. So there is ambiguity. So the labor law is, there are many laws. It's not the lack of laws, there are many laws. So if I give another example, section 265, there is a definition of labor. Labor means any person, including apprentices, legal, regardless of express of implied terms of his employment, who works in any establishment or industry directly or through any contractor by whatever name called, or wages or money employed to perform skilled, unskilled, manual, technical, business development, or clerical work. So once they are considered as a labor, now once they are labor, if they are harassed, so under which law they will go? So there is a ambiguity, I would say, that which law they will follow according to how they are defined. Are they defined as a labor? Are they defined, how will be they defined? Because they will be defined as a labor. Now, if they're defined as a labor, which labor act will be defining? So there is ambiguity, and connecting to a specific law is sometimes is very difficult because there are too many labor laws are available there. There are also a gap in terms of capacity of organization to ensure compliance. Um, For example, through High Court provided compliant committee will carry out the investigation. There are lack of skilled and capacity staff to carry out professional investigation SEAH issues. So now there are not High Court has been given the guideline to create the committee, but the committee is not aware of the act. So again, there is a gap that how to create the committee. Can you go to the next slide, please? Now, there is I would say, there is a mechanism how to get the justice, right? So we know there are steps in the formal justice system, right? So overcoming now those gaps, I will talk a little bit about later, but what are the gaps? Gaps and weakness in the formal justice in them delivering justice. Now, once they know about those guys, now what is the perception in the general people? They really don't know what will happen because there is no time frame when this justification or the result or the verdict will come. There is no specific time frame. That's why people does not want to go in the court. It's a very long and lengthy process, and people, the normal general civilians, they really are not really motivated to run in the court, and sometimes they do mutual agreement and they don't want to continue the case in the court. And there are a lot of corruption happens in the court, and sometimes it happens. I do not want to talk about that, but and especially once we go with the gender issues, we go in the court regarding the gender issues, especially we say gender insensitivity in the court level, especially in the justice system level. I have seen gender insensitivity. We are in the very last moment. We want to wrap up in 1 minute. And I want to talk about social norms and barrier and social norms. And I want to talk about reporting challenge. There is a challenge, it's very strong, which is where I want to do report. We really don't know where to report. And where people doesn't know the way of reporting, and especially once we complain about an employee or a worker, then they are maybe terminated from this organization and they go in another organization, they work freely because nobody knows what happened to other organization, and they keep doing same thing in that same organization. So there is no law what happened after this punishment or after that case. So I believe there is a gap. There is no follow-up after this case, and there are no consequences after that case, or there is no a follow-up of those perpetrator, how he should be in under the law. So we think there should be any law and act so that he or she or any worker will be identified that why he was accused. I think this awareness program is very important to raise the cultural sensitivity and including content on the legal rights of the victim and survivor in the awareness raising materials. And like this webinar, I think this is very impactful for everyone. We think, yeah, we can talk about these gaps and overcoming these gaps. And I would like to thank everyone for giving me this time to share all my learnings and experience. Thank you, Dilipda, and giving us this all very invaluable information. And we have tried to discuss that how to address the gaps and what are the compliance issues are there, what are the gaps are there, how the organization can work, and what they need to do and what can be their steps. And now we are in the last part, receive any questions and you may have. I kindly ask you to take a minute to respond to the question on your screen. And please use your chat box to place your questions. And I will request Dilipda and Nazliapa to join in this discussion. First question we received. Any specific law regarding SEAH and safeguarding? The question is towards Nazliapa. I think uh, as far I know, there is no specific law regarding safeguarding or SEAH, but there are laws where we can find reference. Well, I have mentioned that you cannot disclose the survivor's identity or keep the confidentiality. Maintaining, Nazepa, your voice is getting echoed. I will request you to check the sound. Do I have to repeat? Okay, though we don't have a specific law, but there are many laws that where we can find the reference. For example, I have mentioned about few reference and principles that their name cannot be disclosed, their identity has to be secured uh, till the complaint is not uh, proved. High Court guideline has been ensured that every complaint has to be confidential throughout the process. So I think High Court guideline ensured the reference, but there is no specific law. There is, coming with the next question. Why it takes a long time to resolve any case in Bangladesh? So we know a little bit, everyone we know a little bit about that. Why does it take long time? I know it is a lengthy answer, but if Dilipda can answer a little bit on this. Well, I would say there is a two party. So, and both party has lawyers, right? So If you see that you are going very straightforward, right, with the simplified laws, but the opposite party doesn't follow the very straightforward way. So they come follow the agreed date today or tomorrow. They don't agree. Uh, they make it around and round. And other point is the justice. They have a lot of case in their hand according to date. All right. So it's not the only case they are doing. They have a sequence, they have a serial. So that is a timing thing, what makes it delay. Now, once receive a verdict, then there is a process that this is not the ultimate verdict. Once you receive a verdict from one court, you have a chance of to go to the second layer of court, like you can do an appeal to the next court. So it's not a short process. It takes a time to go to the next court. So this makes this process very lengthy. And I actually want to enlighten to the previous questions. Though there is no specific law, but we are actually making sure the safeguarding issue with the light of High Court guideline. And today we have more question. I think we cannot answer all the questions, but we will make sure all the question is answered through the email. I will move to the next question. So, do we have any report with evidence that what is the success rate of this case of which received justice regarding safeguarding or SEAH issues? To Nazli Appa, if I, if I talk in very specific, it's not possible to give you a statistical answer. What is the success rate? But we have few success stories. But I do not have the statistic data in the country that is available right at now. But overall data is not very satisfactory at this moment. But we do not have any separate unit who works for safeguarding issues here who collect all those statistical data. So we do not have that percentage yet. For how much our country law is applicable in the Rohingya crisis? Well, according to the status of Rohingya, we didn't give them a refugee status. So the Bangladesh Act will not be applicable in the Rohingya crisis. Well, there are few reference which actually can be implicated, but not every law directly can be implicated on the Rohingya crisis. Well, if they are facing any crime, can they ask for justice in the court? We can, yeah, they can definitely ask for the justice in the court under the act. Well, there is a research report available that how Rohingya group can actually claim justice under the total Bangladesh Law and Act. So that is available in the online. I can recommend to go through that and for their queries. Well, we have a little bit of time. Yes, you may see that the evaluation question form. Requesting all the participants, please take a minute to fill up this form. This is very important for us to know your opinion, that how impactful this session was. It helps us to know this is a webinar helped you or not, and how we can improve our next webinar, and how these things actually can help you so that we can make our webinar better. And we have 3 minutes left in our hand. And if we can spend these minutes in our feedback form, and please, I will request if you have any additional suggestion, feel free to give us. We have few more questions. Let me see, any other question is there? Okay, if there is a criminal offense, but victim doesn't give the consent, what we can do? What we can do? If Nazli Appa or Dilip, anyone can give answer to that. Well, there is a specific law. If the victim doesn't give you the consent, you cannot do anything. Because if there is a case, you cannot do anything because victim is the main person who has to give the consent to start the case. Other than that, we cannot move ahead with anything. So we cannot, I mean, you cannot do anything on this case. This is the starting point. Otherwise, with whom you will run this case. Um, I would like to remind everyone one more time that we have evaluation form on our screen. Please fill this up. And we have received a question regarding investigation, which is a very big session, I would say, which is we didn't cover in this webinar. So I would like to request everyone to go to our resource hub. We have wonderful resources there. I will request everyone to go there, check our other resources. We have Nigeria Hub resources, very impactful information there. Please check that. And you may find important and relevant informations there as well. And you will find our, this event is recorded as well. You will find the recorded event in our webinar. And I would like to thank Nazli Appa and Dilip Da for your very important and invaluable information for sharing with us in a very short time. And I would like also thank the RSH team who is working behind this webinar. And I would also thank all the attendees and participants. Thank you for giving your time. We are closing this webinar here. Thank you so much.